What is interesting is obviously the law isn't clear or different in states because I have seen 4 lawyers all with different opinions on this. The law is definitely different in different states. What you're able to do in New York when it comes to Medicaid is very, very different than what you can do in Florida. So yes, the law is 100% different. Now, that being said, there's also a lot of different types of trusts out there or planning tools out there. So the video that I posted that this is in response to specifically had to do with revocable trusts. And what I was talking about was, is this, a protected asset, or can you put assets in a revocable trust and protect them from Medicaid, or protect them from having to be spent down before someone can qualify for Medicaid? And the answer with regard to a revocable trust is no. Reason being, when you have a revocable trust, the person who's actually creating the trust, putting the property in the trust, often called the grantor or the settlor, they retain control over those assets. They can do anything they want, move them in, move them out. They're still essentially their assets. So for that reason, and because they maintain control in a revocable trust, when it comes time to qualify for Medicaid, that's one of the assets that's going to be factored into the equation. So to qualify, you have to have under a certain amount of assets. What Medicaid is going to look at is any financial institution account that you have, bank accounts, CDs, investment accounts, bonds, etc. They're going to add that all up. That's one of the numbers that they're going to be looking at. They're also going to look at the cash value of most life insurance policies. As long as the policy is over, I believe it's like $2,500. They're going to use that cash value. They're also going to be able to look at the value of any vacant land you may own, a second vehicle, as long as that second vehicle is under 7 years old. They can also look at jointly held accounts, so accounts that you might hold with your spouse. So these are the types of things that Medicaid is going to look at to see if you qualify, if you are under that limit that you're allowed to have on assets, so that you can actually be put on Medicaid. Just because you can't do this or move things out of what's being considered to qualify by using a revocable trust does not mean that there aren't tools out there in any state, different depending on the state, that can allow you to do this depending on the type of planning that you're permitted to have in that state. So there's a different type of trust called an irrevocable trust. There's more than one kind, but irrevocable trust can be, and often are, an excellent tool for Medicaid planning. So it sort of depends on what stage of the game that you're in, but if you are not currently needing Medicaid and you're thinking that this could be something in the future, maybe 7-10 years down the road, so you're definitely safe from the Medicaid 5-year look back period, where they can look back 5 years and recapture assets that you might have tried to transfer out of your name in order to qualify for Medicaid. If that's not something that you're concerned with because you have some time, well, you can set up a certain type of Medicaid protection trust where you can transfer assets into an irrevocable trust. As long as they are in that trust for at least the 5-year period, they're not going to be counted against you for Medicaid qualification. Now, there's other tools too. In Florida, we have the luxury of being able to use certain types of trusts, again, irrevocable trust, in order to qualify somebody for Medicaid, and these particular trusts aren't subject to the 5-year look-back period. So there are different tools depending on what state you're in. The most important thing to remember, though, is when you're utilizing something like an irrevocable trust, you really have to make sure that the person who is the trustee, so they're actually going to be holding those assets for you in trust, or they're basically taking over as the owner of the asset, holding it for a beneficiary in trust, is what I meant to say. So you have to make sure that that person who you pick is someone who you can really trust, because you are effectively giving up your ownership and your control of those assets when you give them to that trustee. Now, that's not to say that these things can't be set up so during your lifetime, certain things can be bought for you or certain things can be done for your benefit, but you are definitely giving up control of that asset in order to get the luxury of qualifying for something like Medicaid, which most of us may need to consider at some point, because even with very high incomes, long-term care insurance is extremely expensive and often not that great of coverage. And I know here in Florida, as an example, the average cost of assisted living, and this is just baseline assisted living, not nursing care, skilled care, memory care, things like that, the average across all of Florida is about $10,000 a month. So you can have a lot of assets, but it doesn't take a long time at $10,000 a month to go through those assets. So it's definitely a good idea to meet with an elder law in your state, because yes, there are different things available in different states, to talk about what may be a good option for you now or in the future. I hope this helps. And if you are in Florida, I would love it to talk to you about your elder care needs, and you can contact our office it's atCAUSE Law Office, and the link is in my bio.